On May the 2nd, Russell Brand is scheduled to appear before Westminster Magistrates Court, charged with a series of offences, uh, including assault and against four women. And the alleged offences span from 1999 to 2005, with locations including Bournemouth and Westminster. And as the legal process unfolds, Brand has mounted a parallel defence, not in a courtroom but on social media. He's put out a video called My Response on Twitter. It's a striking example of what one might call trial by narrative. And the charges are grave. The allegation in Bournemouth in 1999, the assault in Westminster in 2001, the alleged assault in 2004, another assault in 2005 and 2004. And these follow a joint investigation by the Sunday Times, The Times, Channel 4's dispatches published in September 2023, which prompted formal police action. The Crown Prosecution Service announced the charges in April, and following months of scrutiny just a couple of days ago. Brand's video is not a confession but a reframing of the issues, and he preempts court proceedings with a character portrait. I was a drug addict, a sex addict, an imbecile, but what I never was a rapist. This rhetorical move distinguishes between moral recklessness and criminal conduct. It's a calculated manoeuvre. By admitting personal flaws, Brand aims to establish credibility while forcefully denying criminal culpability. The implication is that one can be dissolute without being violent, chaotic, but not coercive. More controversially, Brand alleges that the legal system itself is being weaponized, suggesting a kind of political or institutional vendetta. He implies that the charges are not just criminal, but ideological. This is a familiar motif in populist rhetoric, the embattled man of the people versus the corrupted elite apparatus. And Brand casts himself not only as falsely accused, but as a victim of institutional overreach. This tactic is reminiscent of other public figures recently: Donald Trump, Julian Assange, even Andrew Tate, who all preemptively claim victimhood in anticipation of a formal judgment. It seeks to shift the burden of proof away from the accused onto the accusers. Even Tommy Robinson, I suppose, has indulged in this defence. It shifts the proof onto the legal system itself. Brand's claim, "You can only see the truth by looking in my eyes," trades judicial process for theatrical sincerity. It invites the public to be the jury. But actually, that's not the case, is it? The public will not be the jury. Or at least the jury will be composed of specific members of the public if it ends up in a jury trial. Meanwhile, the institutional response, internal investigations by the BBC, Channel 4, and Bani J UK, it complicates matters. While these found no direct evidence that staff knew of the alleged assaults, they also reveal a culture in which people felt unable to speak out. The case thus inhabits both the judicial and the cultural realm, where institutional silences and informal behaviours become part of the wider narrative. There is a tension between due process and public discourse. On the one hand, Brand is entitled to proclaim his innocence. On the other, broadcasting such denials before trial can be seen as an attempt to influence public perception or even intimidate potential witnesses. The question becomes not just is he guilty, but is it appropriate to run a parallel trial in the media? Courts adjudicate on evidence, not charisma, and yet charisma has always had its uses in matters of law. Brand's fame affords him a megaphone. Many accused individuals do not have the opportunity or the platform to address the public directly. This asymmetry is significant. The ability to shape one's own narrative in advance of trial risks tipping the scales of public sympathy, particularly in high-profile sexual assault cases, where the presumption of innocence must contend with a culture of survivor advocacy and public vigilance. Russell Brand's public response passionate, rehearsed, and deliberately ambiguous, raises complex questions. It challenges us to consider the relationship between fame, media, and justice. And his courtroom defence is yet to begin, but his campaign for exoneration in the court of public opinion is well underway. As May the 2nd approaches, we must ask, are we prepared to separate legal judgment from spectacle? Or are we increasingly governed by a system in which justice is determined not by facts, but by the number of followers?